Good morning, good afternoon, good evening, depends on where you are. My name is Joe Zhang. I'm a law advisor at IISD. Together with my colleague Xia Jialing, we will facilitate the session today. Welcome to the third session of the series of IISD webinars on investment law and policy. The purpose of this series is to allow officials from developing country governments and regional organizations to access information on developments in international law and policy to negotiate better treaties and contracts and prepare for and manage investment disputes. In this series, experts, academics, and practitioners who specialize in international investment law and policy will discuss a range of issues arising in investment negotiations and dispute settlement. In the past, we have discussed ancestral process on ISDS reform and the topic of investment facilitation. You can access the past events through ISD's websites. Today's topic is developing a negotiation based on model investment treaty. During the past 2 decades, more and more discussions have taken place in addressing the imbalance caused by the existing international investment law regime. In terms of treaty practice, we have seen many countries attempt to address this imbalance by developing or revising model investment treaties. UNCTAD study showed that in 2015 alone, at least 50 countries or regions were revising or have recently revised their model investment treaties. In recent years, we see more and more countries joining this process of reviewing or revising model treaties. Not only developing countries who have long voiced concerns on the flaws of the existing system, but also an increasing number of developed economies. For example, earlier this year, the Netherlands have adopted its new model treaty. And in August, Canada also announced publicly that it is reviewing its model treaty. My colleague Sarah Bruman has prepared a background note for this webinar. I highly recommend you reading it after this session if you have not yet had a chance to. You will find the link at the event page. The note answers some of the questions such as who is updating their model treaty, who are countries updating their model treaties, how are countries updating their model treaties, and what is contained in the new model bids. Today at this call, we're going to take a step further and try to address a few more detailed and practical questions, such as what are the benefits and risks associated with having a national model investment agreement? What are the key considerations for the process of developing a national model? What are the strategies for negotiation based on a model? And how to determine the negotiable provisions versus the red lines? For these, I'm happy to have 2 distinguished experts with us today. Ms. Patience Okala from Nigeria and Dr. Jonathan Bonecha from University of South Wales, Australia. Just a quick note before I give the floor to our speakers. Due to some urgent matters just came up to her attention, Patience needs to excuse herself halfway through our webinar. So we made a little adjustment to this agenda. We're going to first ask Patience to share her thoughts and experience on today's discussion, and then open the floor directly to questions and answers addressed specifically to Patience. Then we will ask Jonathan to present his studies and findings and to answer the remaining of the questions raised by participants. So for the participants to this call, to ask questions, please feel free to use the Q&A button at the bottom of your screen. You can just click on the button and type your questions, and those questions will be showing up on the panelists at our host page, and we'll be able to submit it for panelists to answer. So without further ado, I'm going to give the floor to Patience. Patience Okala is Deputy Director and Legal Advisor of Nigerian Investment Promotion Commission. She serves actively on Nigeria's International Investment Agreements team and has led a number of BIT negotiations between Nigeria and other countries, including the negotiation of the Nigeria-Morocco BIT, which prominently featured in UNCTAD's 2017 World Investment Report for its reform-oriented provisions. She was also actively involved in the reform of Nigeria's model BIT. Patience, please.
Good morning, everyone from Nigeria, and thank you very much, Joe, for having me on this webinar. I think the topic for this morning is a very important one for developing countries. We're looking at developing and negotiating based on a model investment treaty. So I'll be speaking based on Nigeria's experience and the things we have found to be useful. First of all, we have found having a model treaty to be immensely beneficial to our negotiations because a model treaty encapsulates what the priorities of the country are, what it is the country wants to address in relation to the BIT, and what the sustainable development objectives of the country is. The flip side of not having a model treaty is like you're going to war really basically unprepared. I hate to use the analogy of a war, but that's the first thing that comes to mind. So if one has a model treaty, it's like you have a position from which you want to begin. In Nigeria, over time, we have found out that we had a number of treaties signed, but they were not meeting the direct needs of our government in relation to the lives of our people. We had a lot of challenges in terms of our environmental degradation in the Niger Delta area, where coincidentally we seem to have the greatest resource, but also the greatest challenge environmentally and the greatest poverty, if I could say. And so we decided to take a second look at our model treaties and the kinds of treaties that we signed. Prior to now, we had treaties that were basically protection-based. So they are treaties that give absolute protections to investors, and without really considering what quality of investments we're bringing into the country. And then we said, in order to avert the kind of situation we're having where there was so much, in quote, investment in the Niger Delta area, meanwhile, it was not sustainable. The investment was not responsible. It was not responsive to the needs of our people. We found it necessary to have a second look at our model treaty. And we looked at it and saw that we needed to come up with a model that showed what our priorities are as a government, a model that captures our sustainable development objectives, a model that speaks to a balance between the rights and the obligations of investors. So we're giving investors a number of rights in our treaties, but we thought that it would be more useful for a win-win situation for investors have to have obligations in addition to their rights. So what we did in 2016 was to take a second look at our model. And by that time, we already had a still ongoing IISD case with Interocean. And we saw what was happening in other countries and how the world was moving very quickly in reforming their BITs. And we had an interministerial team, which we usually use an interministerial team in negotiating our treaties. That interministerial team comprises of key agencies of government that deal with investment. So we have our Investment Promotion Agency, we have our Federal Ministry of Justice, the Ministry of Industry, Trade and Investment, we have the Ministry of Finance, the Ministry of Foreign Affairs, we have our Inland Revenue Service as well. So we came up, that is the team that normally negotiates our treaties. But in relation to our model investment treaty, the Investment Promotion Agency led the process, and we had the Federal Ministry of Justice, Federal Ministry of Industry, Trade and Investment. We also had people from the academia, and we had arbitrators who were already in the field. So we sat and took a look at the treaty to consider the text and the content of the treaty, to see what our model really captures. And we thought of including clauses that would promote our sustainable development objectives, which include our environment, which include preservation of labor laws. We have a large population of youth. We're dealing with unemployment. We thought we wanted to attract responsible and responsive investments. And so we sought to create a balance between one extreme of investment protection and the other extreme of just looking for investments for sustainable development. And then we came in where we consider to be somewhere in a compromise middle. I came up with that. So that is what we've done. So to answer the question as to whether there are benefits. I think there are benefits that accrue, the immense benefits having a national model investment treaty, because it gives you a point from which you can negotiate, as against just going open-ended, using somebody else's proposal, which captures what their own priorities are to negotiate. So it has helped us. And in terms of key considerations for the process of developing our national model, like I just mentioned to you, we did quite some consultation with key stakeholders, people who were in the field, people who were in government, people who interface with investors, such that I work with the Nigerian Investment Promotion Commission, so we have a fairly good idea of what the issues are for investors. We consider ourselves to be the friend of the investor in government. So we did that over a period of consultations and made sure that our treaty encapsulates the priorities of our government and what our economic priorities and our sustainable development objectives are. We didn't want to continue to sign BITs at the expense of our sustainable development as a country. So basically, that is what we've done. In terms of challenges or things that we have faced, it wasn't easy to get those provisions into our BITs, but we've done that through consistent engagement with the policymakers and the decision makers. I don't know what happens in other countries, but we find in ours that the negotiators are really not the decision makers at the highest level of government. So they're the technical experts. They speak to the technical issues that should be covered in a BIT and try to make sure that government's priorities are covered. But we also have to interface with the decision makers who eventually sign off on what treaties are ratified and what treaties are not ratified. Sometimes it's a bit of a challenge, but we find that with continuous engagement, we've been able to shift the needle a bit. With some government officials, it is easier than others, but we have been lucky in the past few years to have had government officials at the decision-making stage who understand the importance of BITs and who also understand the importance of how badly worded BITs could have consequences that are not favorable to the country. And we have decided to cover as much mileage as we can while we have these particular individuals in government. And that's what we've done for the past few years. We are currently looking at, after the model, what we did was also to, aside from doing the model, because there are a large stock of old generation treaties which can also bite. So we're also reviewing the text of what those treaties are. We have done that. We've tried to map them using 20 critical and 20 reform-oriented provisions to map what the content of these treaties are, with a view to deciding the next best steps. So our model treaty now has sustainable development objectives, balance of rights and obligations. We have things like articles like circumscribed MFN and NT. We have temporary safeguard measures to transfers. We have enterprise-based definition of investment. We have rights to regulate specifically provided for. We have other innovative provisions, including provisions on anti-corruption, which is a challenge that we are facing in the country. We have those on investment and environment, on CSR, on corporate governance, on post-investment obligations, a wide host of issues that we consider to be important to us from this side. I'll pause for a moment and see if anyone has any questions.
Thank you, Patience, for introducing your experience from Nigeria's perspective. And now we open the floor for participants to ask your questions through the Q&A function of our webinar. So again, at the bottom of your screen, you'll be seeing a Q&A button. If you don't see that, you can click on the control panel at the top of your screen. There's a window, a tab that you click on that, and it says there's a function to show meeting controls. Then you will be able to see the Q&A button there. So feel free to ask any questions by typing into your questions into the Q&A box. So as we're collecting questions from our participants, I have a question to Patience, if I may. So Patience, you mentioned the that in Nigeria, which I think is also a common situation as well, that policymakers and decision makers, the role of policymakers and decision makers is saying that the negotiators are not really, not always the highest level of, at the decision making level. So, you've alluded to that a little bit already, that it's important to have the buy-in from the higher political level to support this reform efforts. Just wondering if you can give any concrete examples or any stories that what happened, and what are some of the good strategies for negotiators that can achieve this kind of buy-in from the high level, if you have any story to share. Thank you.
Okay. All right. Thank you, Joe. So we've had a number of interesting experiences in that regard. The first one or two stories that readily come to mind are in relation to, I would share some of the experiences we've had after we had come up with our new model, and we were thinking of reviewing the text of other concluded BITs that had not been signed off or ratified. So we had pressure from above. We had instructions from above to say we should ratify treaties that were not in line or were not in sync with what our new model treaty was, which was signed off already by government. It's not easy to go back and say, no, you're not going to sign and all of that, but with continuous engagement. So what we did was to try to engage as much as possible, because the decision makers themselves actually want what is best for the country. Whether they understand it in detail is something that probably differs from person to person. But when you are able to express that your position or the position of this treaty that has been signed off is in the best interest of government, is in the best interest of the decision makers, what we found to be useful is written engagements. When you write and then you explain what the consequences of each of these provisions will be if they're signed off the way they are.
Okay, I think we're experiencing some technical difficulties from Patient's end. There could be some network issue. Let's give Patience just another minute. Also, I hope Patience will be able to join us again.
Joe, can you hear me?
Yes. Okay.
Hello, Joe.
Yes, Patience.
Oh, I apologize. We have some technical issues from this side of the world. It happens sometimes. So I was saying that what we have found to be useful is written engagements with the decision makers. So we find that when we put it in writing, to say these are the consequences of taking these kinds of decisions. This is the consequence of signing of a treaty with this kind of provisions. This is the effect to have on our sustainable development objectives. Government is looking for employment. Government is looking for responsible, responsive investment. If we sign up on this text or that text, this is what the consequence will be. It hasn't been easy, but we find that government listens, at least from the chief executive of the IPA, which I work with, to the ministerial level, currently to the presidential level. We've had to make those written engagements up to the presidency, and luckily for us, so far, we have had the support of the decision makers. It hasn't always been easy, because there are times that pressure will be put, but since our model treaty came into force, I really cannot think of one instance where we were pressurized into finalizing a treaty that was not in the best interest of government. And I have to say that honestly. We've had those experiences previously, but since 2016, we write, and the chief executive of the IPA that I work for understands it completely. And she takes it up because where her voice reaches a lot farther than ours can. And they understand. So my take would be engagement, engagement, and engagement. And of course, it helped a lot that in the UNCTAD's World Investment Report of 2017, our model treaty was featured prominently for our reform-oriented provisions. So when you put that alongside your submission or your memo on what the implications will be of signing off something that is not consistent with what the model carries, and they see that an organization like UNCTAD and other organizations are sharing the work done, they take a step back and say there must be something right about what is being done. So that's our experience.
Thank you, Patience. So yes, well, it's a really good suggestion in terms of engagement. But a question is that when you need to engage with the public officials, senior officials, and then also writing memos, all these takes time. And then here's the question from one of the participants, Kenneth, and asking directly to Patience, saying, how do you advise your superiors when you are pressurized to finalize a BIT negotiation almost immediately? Patience, to you.
Yeah, Joe. So we've had that scenario as well. And I'm sure a lot of the people on the group have had that scenario where sometimes you get superiors traveling for different national functions and they really want to sign something for the optics, for the cameras. So we advise, if you want to sign something, it must not be a BIT. It should not be a BIT. And in reality, it would not be a BIT. So we will sign anything else that is non-committal, but a BIT, so we come up with other options of something to sign. If the intent is to sign something, so you want to sign a memorandum of understanding, you want to sign something. So we give you options of what to sign, but we also stress that a BIT is a very serious document that can bite, and that is currently biting to some extent in the Interocean case that we currently have before ICSID. And like I said, luckily for us, our superiors are listening. As at today, they are still listening.
Thank you, Patience. So I'm still waiting for other participants to send in questions. Please feel free to send in more questions if you have for Patience. While we're waiting, just another question to Patience. We know that models, well, the negotiations of treaties, they change every time. Depends on your negotiation partner, your national, as you mentioned, national strategy, national priority. So how do you ensure that your model also develops with your negotiation strategy, with your national priority? How do you ensure that this becomes a living document? Do you do periodic review and update?
Hello, Joe. The short answer is yes. So we don't do every month review or something, but we've done this model in 2016, and as we speak, we found out, because it's not a perfect document. I speak very highly of it, but I'm very aware that it's not a perfect, foolproof document. So the more we negotiate with it, the more we find that there are some gaps. And sometimes we listen to experiences of other countries, and we find that some countries have worded certain provisions better than we have worded ours. And we're making those notes. So yes, the answer is that we intend for it to be a living document. We intend for it to be reviewed, and we are currently putting down notes for a further review of what we currently have. And sometimes also in the course of negotiations, you find countries come up with, very interesting positions, and that make us go back and look at what our text is and say, we think we should take this out. We think this is not as clear as we thought it will be, you know. So yes, it is a living document and we're working on periodic review.
Thank you. So there is another question coming up from a fellow Nigerian, Dr. Zodima Adireje. I hope I pronounced your name correct. Apologies if I don't. So how is the NIPC promoting investments in social protection for Nigerians? That's for Patience to answer. Patience, thank you.
So NIPC is the agency of government empowered to promote investment in all areas in Nigeria, all areas. So we do it from investment promotion, we do investor relations, we do aftercare, we do policy advocacy. We look at what, we do an impact assessment of what the current investment climate of Nigeria is. And then we come up with advocacy, we engage investors, Okay,
I think there are some network difficulties again. Please bear with us for about a few seconds. So usually the network will pick up again by itself. So Patience, can you try again?
Hi, Joe, can you hear me now?
Very good.
Yeah, so I was saying that within the policy advocacy ambit of our statutory mandate, we engage both the investing community and government. We stand somewhere where the liaison between the investor and government. So it is a vantage position. We see things from the view of the investor, and we can also see things from the view of the government. So we're best placed to push for advocacy, for social protection. We do an impact assessment of what the investment climate is, and then we push within government for changes to be made, for priority to be given. The NIPC Act empowers NIPC to come up with priority sectors for investment, advise government on what those sectors should be, on what incentives should be given to promote those sectors and the like. So in executing that mandate, NIPC pushes for investments in basically all areas, including that of social protection. So we see where there are gaps, and then we push for government to take necessary steps to address those gaps.
Thank you, Patience. I don't know how much time you still have, Patience, but we do have a few more questions lined up for you. Would you be able to address those, or you need to go?
Yeah, I still have like 10, 15 minutes. But
oh, that's perfect.
Yeah.
That's perfect. So we have 3 more questions. Okay. So this is from Diego Gomez. How often do you consider states should update this model? If an economic background changes so often, wouldn't it be a bigger burden to create models that will become obsolete in a short period of time than negotiating directly a new one in every new negotiation? Would you like to address that?
All right, so thank you. I don't think the object is to negotiate a new model each time something changes in the economy. So in negotiating a model, I also believe it should not be a hastily done process. So it's not something you do without thorough consultation. I don't believe it's something that you should be done also just to meet the current realities. So you're looking at the current realities, but you're looking at something that could span over a couple of years before you change it. So you don't want to be changing your model BIT every year, because it will not provide the atmosphere of certainty and the predictability that investors will require to come into your country. So if you have a new model, you want the model to have a certain lifespan. So you do an in-depth kind of due diligence. You try to consult as widely as possible, because you're not just doing a model that will suit your government's objective. That is one extreme. You're trying to get investors to come into your country. You cannot be leaning on one extreme and say every time our economic policies change, we're going to change our model. I think that is one
Okay, thanks, Patience. I think the last sentence was eaten up, but I think it was okay. We got the message that the reality and also and you strike a reality, strike a balance between reality and your national priority. So that's the answer to Diego's question. I hope that address Diego's question. And also, there's a question coming up from Ivana Savage. What are the main lessons learned from Nigerian experience? Patience, can you hear us? Because I saw you were just...
Hi, Joe.
Okay, good. So this is another question for you. What are the main
Okay.
lessons learned from Nigerian experience in regards to the investment disputes whereby there have been a breach of a treaty that was a result of the government's obligation to protect human rights and the environment?
I do not know that we have those kind of disputes on a BIT level as we speak, on a breach of a treaty based on human rights violation. I do not know that we have those kind, but those are scenarios that we have anticipated and made provision for in our model. So that's the short answer to that.
Okay, thank you. So last
Hello,
question.
Joe.
Yeah. So yeah, well, we can hear you, Patience. So last question here from Susie Nikiyama.
Yeah.
Do you have any non-negotiable provisions in your models? I think this question also addressed to some of the concerns that raised that whether you should put any red lines in your models and how to, if so, how do you determine what are the provisions negotiable, what are the provisions non-negotiable, and how do you instruct your negotiators in a negotiation setting that what are the provisions they can choose and how far they can go?
Yeah. Okay, so to answer this question, I have to give you a background on why I have to go back to why we came up with a new model. We came up with a new model because we found that our old model was not meeting our sustainable development objectives. It was not creating that balance that we required between the rights and obligations. It was not addressing issues of corruption. It was not circumscribed, the MFN and the NT and all and the like. So in relation to the question that was asked, yes, there are non-negotiables. Because if we had done the pain of sitting down to come up with a new model that would push for responsible and responsive investment in line with our sustainable development objectives, then those areas for us are non-negotiables. Because if we had done that, to go to a negotiating table and throw all of that out the window would be a complete waste of the review process. And I can tell you that we have had pushback from countries. First, we have negotiated with a number of countries using our new model that sat very well with them. We've negotiated with a country who came with their model, saw our new model, and decided to do away with their model, and we negotiated completely on the basis of our new model. We've had another country that took a large portion, like 50% of our model, 50% of theirs. We had quite an area of convergence already because they too were thinking about balanced BITs. And then we've had negotiations with the country who thought that all our new inclusions and reform-oriented provisions should be picked out of our model before negotiations can proceed. And needless to say, those negotiations did not proceed because for us, we consider them to be non-negotiable. So we've looked at ourselves as the developing country. Beyond the BIT, there are other factors that make investors come into Nigeria. And we're becoming increasingly aware of what those factors are. One thing it says to us is that we may not be as desperate as we probably believed previously. So we're a bit strengthened and emboldened on the negotiation table to say we want a BIT. We don't want a BIT that will only serve our sustainable development objectives, period. that is an extreme that we're not going for. But we're making an effort to create a balance such that it is a win-win situation, both for the investor and for the host state. So we find provisions that go against our sustainable development objectives, that go against what we want in relation to our environment, labor, corruption, and the like, then those for us are non-negotiables. If we find investment in BITs that go against those key provisions that necessitated the review of the model in the first instance, to us, those will be no-go areas, and they are non-negotiable. So we've had the experiences from three ends. We had full resistance, we've had no resistance, we've had a compromise, and now we have countries writing to us to say they too want to renegotiate because they are looking at balanced models themselves. So I think we've gone round the whole spectrum. We've had the four classes of experiences, if I'll put it that way.
Thank you, Patience. So I think this can, since Patience answered all the questions that we have so far, and I think it's a good point that we transition our discussion to Jonathan. So Jonathan is Dr. Jonathan Bonachat is also a colleague at IISD. He's an associate with IISD's Economic Law and Policy Program. Meanwhile, he was also a senior lecturer in law at the University of Newcastle. His research focuses on international investment law. He has published several articles and books on the subject, including The Political Economy of the Investment Treaty Regime, which was recently published by Oxford University Press last year. He has also advised the governments of both developing and developed countries on investment treaty policy and acted as a lawyer in major investment treaty arbitrations. So here I'm going to give the floor to Jonathan. Again, thank you for Patience presentation. Jonathan, please.
Thanks, Joe, and thanks very much to Patience for her wonderful insights on the practical issues involved in developing a new model investment treaty and negotiating on that basis. Jaja, can I have the next slide, please? Thanks. So I guess the focus of my discussion, it's going to cover some similar themes, but I wanted to begin by putting discussions about model investment treaties, developing a model treaty into a slightly broader context, I guess. If we think about the current investment treaty system and the sort of 3,000 or more investment treaties that are in force, in fact, almost all of these treaties already reflect some country's model. But what's happened is that those most existing treaties were developed or were negotiated on the basis of developed country models that were first developed in the 1960s and the 1970s when not much was known about how investment treaty arbitration would operate in practice. And when developed countries really weren't that interested in the risks that investment treaties posed for countries that were destinations for foreign investment. Their assumption was that their models reflected their interests, where they would always be the exporter of capital, the source of foreign investment going out, and they understood the purpose, developed countries understood the purpose of their investment treaties largely to protect the interests of their investors in developing countries. So in fact, the current system, of course, already reflects model treaties, but it reflects model treaties that we now regard as deeply flawed, both in the way that patients describe that they fail to achieve a balance between the rights of foreign investors and the obligations of investors and the regulatory space of the host state. And they're also flawed in the legal risks to which they expose host states to. So that's, I guess, the sort of background to the discussion where we sort of come in. And although it's easy to kind of just jump straight into a technical discussion about models, about drafting the most favored nation provision or the definition of investment or the dispute settlement clause, I think one thing that really came out of patients' discussion and that I would also emphasize is a kind of wider policy rationale for developing a model treaty for a country. And I see the sort of core rationale here as the chance that developing a model opens up the opportunity for a country to clarify what is actually the policy objective behind its investment policy generally, and how investment treaties relate to those wider objectives of that country's investment policy. Because, of course, existing investment treaties weren't developed through a process that really thought those issues through. I think there was just more of an assumption that investment treaties would automatically attract more foreign direct investment. And we know now that assumption hasn't been borne out in practice. And also the assumption that more foreign investment was a good thing regardless of the quality of the investment or whether it was sustainable or responsible. So I think the chance to develop a model is a useful opportunity to move away from the sort of continuing with the old style of treaties and to step back and ask more basic questions about what are the actual policy objectives in the first place, and then to sort of work from there to say, well, what sort of investment treaties, what sort of provisions in investment treaties would we need to achieve those objectives, and what sort of provisions and treaties are not necessary to achieve those objectives. So that's one real benefit of developing a model. And I think related to that, I see a benefit in the ability that discussions around a model have to provide an opportunity for more input into treaty development than is possible in individual negotiations. So individual negotiations are obviously can be done under time pressure. There can be confidentiality issues. And there's not so much control over the process, whereas for a country developing a model provides an opportunity for a much wider discussion. For example, investment treaties affect all different parts of government, and I was very interested to hear patients reflect on how Nigeria had used the process of developing a model to bring in perspectives from across government. There's also important questions in federal states about how investment treaties will affect the balance of the powers between the national government and subnational governments. So these are sorts of issues that are easier to have a consultation of and to work through in the context of a model. Also, expert input, public consultation. And I think a final benefit of this policy process, and this is something that patients also really touched on, is that there is a chance in in going through the process of developing a model to use that as part of the communication strategy within government, to part of this engagement to inform higher level decision makers about the importance of a careful investment treaty policy. So both the risks of old style investment treaties, but also how other more carefully thought through investment treaties can better achieve your policy objectives. So can I have the next slide, please now, Zhao Zhao? So moving on now to some of the other policy rationales for developing a model. And here I think I'm touching on things that most of the participants will be much more familiar with. But the process of developing a model is also a real opportunity once you have clarified the policy objectives that are driving investment policy, to sort of link those objectives to the legal content of the treaty. And so that process of thinking through might involve reconsideration of standard investment protection clauses found in existing treaties, like the fair and equitable treatment provision or the most favoured nation provision. It might involve thinking about the design of investor-state dispute settlement, or whether that should even be included at all. And also it involves sort of thinking about the drafting of new provisions addressing the sustainable development dimension of investment provisions on issues like corruption, environmental and social impact assessment by foreign investors, and that sort of thing. And in the process of developing a model is also this opportunity to sort of reflect back on existing treaties as part of a wider strategy of review of the existing treaties in light of policy objectives that you or your country is seeking to achieve through new treaties. And this is something I think the patients also mentioned, that the process of developing a new model was also useful in kind of triggering some reflection and having a sort of set of benchmarks to look back at existing treaties and have a strategy, begin to develop a strategy about how to deal with those. So I think these are some really strong policy reasons for developing a model treaty. And if I can have the next slide now, please, Zhao Zhao. I'll talk just for 5 minutes more about some of the uses of a model treaty that are more related to the negotiation process itself. So here, I think I've got 5, and they're related, 5 benefits of having a model in helping a country approach negotiations for new investment treaties. So the first one, and I think perhaps the most important, is that a model treaty, having a model treaty that reflects your investment policy, is a useful benchmark in deciding whether to open negotiations for investment treaties with another particular country at all. So what I mean by this is that if you've gone through the process of developing a model treaty and it's clear that you've decided that certain types of provisions should be included and certain types of provisions shouldn't be included, then it becomes very clear very quickly, if another country turns up with a very different sort of proposal, that it's unlikely to be possible to negotiate a treaty that that both sides find satisfactory. And I think a lot of the practical difficulties in the sort of detail of negotiations come from the fact that negotiations are opened in situations where perhaps there was no realistic prospect that the other side would agree to a treaty that satisfies your interests. And that can then create a lot of pressure, potentially from a higher political level, to compromise and agree to a treaty that may not be in your country's interests. So a model is useful there in deciding whether to open negotiations in the first place. It's useful potentially in negotiations as a way to set the initial default or the first draft of the negotiating text, which then becomes the default for the agreement if it's not modified. And that in the past has been a very important way that developed countries have achieved their objectives by using model treaties, by using those treaties to set the terms of negotiations. But models are also helpful for a number of other reasons, even if it's not easy to reach agreement with the other side. So a model can strengthen your negotiation position by justifying refusal to compromise on particular issues. So I'm aware that this strategy has been very effective for some countries. The US in particular uses it, so they will go into negotiations and say, well, this is a model and we've developed it through a very careful process and it's been approved by our parliament. So it's just not possible for us to compromise because we would never be able to get the compromise position or a different position approved. So having a model that has been developed and approved through government processes can be useful to justify your position. Internally, it can also help your negotiators prepare for negotiations by identifying what sort of issues are crucial or red line issues that you are not willing to compromise on, and what are the issues that you might be willing to compromise on in some circumstances. And relatedly, the model can be very helpful, especially if it includes commentary on the on the different provisions, in providing a resource for your country's negotiators who might be under time pressure to make decisions during a negotiation. And can I have the final slide, please, Xiao Xiao? The last thing I wanted to touch on briefly is a few sort of reasons I've heard where people have said, well, maybe we would like to have a model, but we don't think it's realistic. And I want to try to, I guess, suggest that some of those reasons are not good reasons against developing a model. So one thing that I've heard suggested is that, well, we don't want to develop a model because that means that we won't be able to negotiate flexibly anymore, and that will make it harder for us to sign lots of new investment treaties. And I guess I have two sort of answers to that concern. So the first one is that I think it's important to be cautious about just wanting to sign more investment treaties for the sake of it. So we know now that there are risks associated with investment treaties, and a lot of those risks depend on the language and the structure of the treaty in question. So I think, having a model is helpful, might actually be helpful to slow down the impulse sometimes for senior decision makers just to go around signing lots and lots of treaties without thinking about the consequences. And I also think if a state does want to sort of retain a lot of flexibility, it's still possible to have a model and use it in a flexible way. So just because you have your model, there's still then a whole lot of other decisions about the extent to which your country would be willing to depart from that in practice. So if there is genuinely a concern about lack of flexibility, then I still think there's an advantage in developing a model first and then trying to use it in a more flexible way rather than avoiding thinking about model positions. Another criticism I've heard about the need to develop model investment treaties is that some negotiators say, well, we don't want the other side to know about our negotiating position in advance. We want to keep that confidential. And I think that concern sort of maybe misunderstands the way that states use models in practice. Because when you enter into a negotiation, of course, at some point you're going to need to disclose what is your negotiating position anyway. So it's not going to remain confidential. But even if you have a model, the thing you can keep confidential is your willingness to compromise on particular provisions. And this is quite common. So you may have your model investment treaty, that might be public knowledge. But if you're concerned about confidentiality, of course, it's completely normal, and most states would keep confidential their willingness to compromise on particular provisions in that model. But the model, nevertheless, is still very important because it provides a focal point in the negotiations, as well as all the other policy rationales I talked about relating to the benefits that come from the process of developing the model. And the final criticism of having a model I've heard sometimes is that, well, you know, we'd love to have a model treaty, but it takes quite a bit of time and thought to develop a model treaty. And I guess my response to that is to say, well, that's true. It can take some time and some resources, but investment treaty claims themselves are extraordinarily expensive and time consuming. And so if we think about maybe the time and the effort it takes to develop a model compared to the time and effort of defending investment treaty cases, and certainly if a state ever loses a case, the expense of that, then I think the effort that goes into developing a model is time and resources that is very, very well spent. And one thing that I would, raise as a question is, if a country thinks that developing a model would take too much time and too much resources, it makes me wonder whether that country is well served in signing investment treaties at all. Maybe if the country doesn't have enough time and resources to develop a model, then it perhaps doesn't have enough time and resources to engage in the investment treaty system because of the costs and the risks associated with that. So I've finished my presentation there, and I'm looking forward to questions.
Thank you, Jonathan, for the presentation. And we heard earlier that patients providing her experience from Nigerian perspective, and here we have Jonathan presenting his studies and findings, and we realized that many of the issues that patients mentioned in the Nigerian context actually is applicable to many other situations. So it's more of from a broader perspective, this is common issues that are faced by many countries. So thank you for both Jonathan and patients for the excellent presentation. And now I'm going to again give the floor to the participants to address the questions, ask questions by by typing the questions through the Q&A box, and then we will read out those questions to Jonathan for him to answer. Meanwhile, again, I'm going to just throw a couple questions towards Jonathan. Jonathan, you mentioned that the models will need to be developed in a realistic and practicable way. Just a follow-up question on that. So for lower income countries that, you mentioned something about the resources and how to most effectively and efficiently use the resources. But what about the lower income countries that may not have that much resources in the first place, and given the treaty, the model development process, as you mentioned earlier, is a process that needs to align with national priority to make sure it's consistent with a national priority. So there definitely needs to be a very resource-heavy exercise on review. So what if the country just don't have that resources for a full review process? What should they do when they decide to draft their model treaty?
It's a challenging practical question. I think, well, there are two answers. One answer is the answer that I can give as an outsider, but is very difficult for someone in government to give to their sort of senior minister. But as an outsider, one thing I would say is that I would say to the minister or the president, if you don't think we have enough resources to develop a model investment treaty, maybe we don't have enough resources to negotiate investment treaties at all, because the risks of investment treaties are very large, much larger than the cost and resources of developing a model. And so if you're worried about those costs and resources, it's a pretty good indication that maybe that state is just better off not negotiating in investment treaties, just not participating. That could be the best strategy. So I know that that's not a realistic answer for many government officials, but I think that's an honest answer. The more realistic answer, I think, is to look around for examples with other countries in similar condition or in regional organizations, and to use their models as a starting point in combination with maybe some input from experts that you trust, although that can be difficult. And so maybe I'll give an example that I'm most familiar with because I worked a lot in that ASEAN region. So among ASEAN means the Association of Southeast Asian Nations, is 10 countries, and they have a comprehensive investment agreement between the 10 ASEAN countries. And I don't think that treaty is perfect, but it's a careful treaty. A lot of thought has gone into it, and it's a much better treaty than some of the old style European model bilateral investment treaties that were developed in the 1960s and 1970s. So if I was thinking about an ASEAN country, maybe one thing I would say, well, is, look, you have this regional investment agreement. These are the investment benefits and investment protections that you offer to your closest partner countries in your regional grouping. And you do it through a treaty that has been developed carefully. Maybe you can use that as your model. So you avoid giving more generous protection, so greater rights to investors from other countries in other investment treaties than you give through your regional investment treaty, which has been developed more carefully. So that's one, I think, practical strategy for a less developed country to sort of use some examples from regional practice as a basis for their own position.
Thank you, Jonathan. I'm glad you brought up ASEAN as an example, because my next question is related to the regional activities. As we've seen in the recent years, there's an increasing amount of regional agreements being concluded as a result of the regional integrating process. So do you see if regional organization has a role in developing model treaties at country level or regional level? And if so, what kind of role they can play? Thank you.
Yeah, I think, so the answer is yes. I think they have a role. I also think that regional organizations often differ from different parts of the world. The level of economic integration, how similar the countries are to one another that are part of the region, these things differ. So I think regional forums are a good place for countries to sort of have these discussions, and maybe if they find that they have common perspectives, to try and pool resources to develop a common regional position or a common model. I'm also conscious that that is not realistic in every regional grouping, so that it will really depend a bit. But certainly there are some excellent examples of regional practice. I'm thinking about the SADC model bit template, for example, as one that might be relevant to countries in that region or even beyond.
Thank you. As we're still waiting for questions from participants to come in, I'm just going to take this opportunity to ask the last question from my end. We see on your last slides, you were rebutting different reasons for against adopting or developing a model bit, and each of the concerns that you addressed thoroughly. But my question still remains that whether there is a situation that really there is no need for develop a model bit, is there any circumstances that would actually advise the government not to develop a model bit? If so, could you share with us what kind of situation would that be? Or do you think it is it's good for every country to develop a model bit regardless of what kind of situation there are?
So I think it would be very rare that I would advise a country not to develop a model. When would I advise a country not to develop a model? One example is if the country has decided that it isn't going to enter into investment treaties at all because investment treaties are not useful in achieving its investment policy objectives. So maybe that's one example. A country might have decided for a bunch of reasons, for some good reasons, that investment treaties are just not a useful tool of foreign investment policy. So in that case, the process of coming to that decision will probably involve a detailed policy consideration, but it won't involve having a model treaty. In some cases, I guess it might be that a country doesn't need to develop a model as long as it has very sophisticated internal thinking about what sorts of provisions it would and wouldn't accept. So maybe that's not in the form of a model, but it might be in the form of some other negotiation support policy document about acceptable and unacceptable provisions rather than in the form of an actual template agreement. But even then, I think the exercise of developing a model is still quite a useful policy exercise because it forces or encourages a country to go through the process of thinking about, well, what are we actually trying to achieve here? Instead of just signing the agreements proposed by negotiating partners. So I think that even if it never sort of plays a decisive role in a particular negotiation, I still think the policy process of developing a model can be really powerful. So I can't, the short answer is to say it's very difficult for me to think of a situation where I would advise a country not to have a model investment treaty.
Thank you, Jonathan. So I see we're towards the end of our scheduled time for this webinar. If there are no more questions, I would like to again thank Jonathan and Patience. Unfortunately, Patience has to go for other commitments, so she already signed off. But we'll definitely make sure that we send our gratitude and appreciation to her by email. But for Jonathan, thank you very much for taking the time presenting at this webinar. Oh, sorry, there's just one question coming up. I think we have to address this before our, okay. Yeah, question just starting to flow in. I don't know if Jonathan, you have a few more minutes to continue?
Yes, of course, Joe. Yep.
Okay. So again, this is from Imana Savage. Similar to the previous question asked, do other legal regimes are automatically applied to investment regimes or not if those regimes should be mentioned in the BIT?
Yeah, I think I understand the question. And so,
okay.
I mean, for example, should the BIT mention international environmental law, international human rights law, and try to deal with the interaction between those questions and the foreign investment? I mean, this is a difficult question that a lot of countries are grappling with, and I think the most important thing is that the process of developing a model investment treaty hopefully encourages or provides an opportunity to think about how those other international legal commitments should interact with investment treaties. And then once you've made some policy decisions, then that can be reflected in the drafting of your model investment treaty. So there can be a bunch of different ways that might be done. So one way would be to include provisions that explicitly prioritize other international law obligations over investment treaties. A similar way would be to maybe craft some exceptions to investment protection provisions that reflect other bodies of international law. Another way to do it would be to make it clear that foreign investors have obligations to comply with the standards associated with other bodies of international law. But so these are all options, but I don't think necessarily that other bodies of international law need to be mentioned in the investment treaty. So sometimes that would be a good idea, but it's not necessary. For example, if the investment protection provisions are just drafted very, very narrowly, it may not be necessary to craft these type of exceptions based on other bodies of international law, just because most of the conflicts in practice have arisen because these investment protections are currently drafted in very broad terms. But I think this is something that's important to work through in the detail of developing a model.
Okay, thank you, Jonathan. I hope that answers your question about side. Great. So Diego Gomez has another question. For developing countries, approaching negotiations for investment treaties vary depending on the other states they're negotiating with. It's not the same to negotiate BIT with Colombia or any African nation than negotiating with US or UK. Do you think a model can cover negotiations with a least developed country or developing country, as well as negotiations with stronger economies? What's your take on that, Jonathan?
So the short answer is yes, I think it can. I understand, obviously, the practical challenges of negotiation, that the practical challenges of negotiation are different, very different sometimes, depending on who you're negotiating with. But one of the difficulties of agreeing to certain types of provisions with some countries and not others is then that becomes a source of leverage in future negotiations. So I've seen several cases where, in the negotiating room, for example, the negotiators from the other side say, well, you have this provision in your treaty with country X, so we also want it in your treaty with us. So as soon as a country starts sort of saying, well, I'll negotiate these types of treaties with one state and these types of treaties with another country, it opens itself up to this sort of pressure in negotiations where negotiating counterparties will say, well, we want the same benefits that this other country had. One of the real strengths of having a model is that it provides you with an answer to say, well, this is our position on what we think is appropriate for foreign investment regardless of the country, and then we're willing to try to stick to that regardless of the negotiating partners in question. So I think a model is useful, and it can be used to negotiate in very different contexts exactly for that reason. And I guess I should mention the most favored nation provision in that context, because one of the risks with most favored nation provisions in existing treaties, of course, is if you go out and agree to one investment protection provision in, say, a treaty with the US or the EU, then that provision can then be imported into all your other existing treaties through the operation of MFN. So I think these are real risks of the idea that, that you negotiate a certain type of treaty with one country, but different provisions with other countries depending on the context. So with that in mind, I think the challenge is then, well, bearing in mind the benefits of sort of trying to maintain a more consistent approach, how is that going to be possible in practice, bearing in mind that different countries are going to try to demand different things from you? And that is the real challenge I see, is sort of thinking through carefully in advance how much flexibility that you're willing to allow to depart from your model in particular circumstances, but then what are the core interests or the red lines that you had? And patients also referred to this, where you say, well, the whole purpose of our model is to reflect a commitment to sustainable investment policy, responsive investment, and that if another country's approach is inconsistent with our vision, then it's just better not to open negotiations in the first place, rather than to try to negotiate on their terms.
Thank you. Thank you, Jonathan. I think it's a good time to close our session today. Thank you again, Jonathan, for the presentation, and thank you all to the participants for your time and your excellent questions. We will, like previous sessions, we will going to put this session online in the coming days at our website, IISD.org. And if you have any further questions, please do not hesitate to contact us. You have our contacts, emails via the registration page as well as the event page. So feel free to contact us for any further questions. And looking forward to seeing you again next time at our next session. Thank you. Have a good day.